computer. Video audio is on. Okay, so hello everyone. Welcome to our first Lunch and Learn for the season. We try to do one of these at least once a month, different topics. We try to branch it between criminal, family, child protection. But some of these, even if you're in child protection, some of the things that John's going to talk about actually would be relevant for you. So we just want to try to get as much information as we can out. If anybody has any feedback you want to give on any of these lunch and learns or ideas for future lunch and learns, wide open, feel free to send me an email about that. So having said that, our first one today is how to do a criminal disposition. We have our very own John Rutherford here today to present on that topic for you. Give you a little bit of background. John was born and raised in Winnipeg. He obtained his JD at the University of Manitoba in 2014. He articled the Phoenix Community Law Center, which was one of the offices that I was at. After receiving his call to the bar, he joined legal aid through the Riverwood Community Law Center. He was there for as a staff attorney for a couple of years, I think it was, wasn't it?
No, 4 or 5.
4 or 5 years, yeah, until I stole him and he transferred back to the Phoenix Community Law Center. I was the supervising attorney at that time. I then left the Phoenix office to come and join senior management, and John took over as the supervising attorney at Phoenix since that time. And that's been what, 3.5, almost 4 years now?
About 4 years now, 4 years in October. Oh.
So John's appeared at all 3 levels of Manitoba court several times, actually. He maintains a practice here in Winnipeg. He also acts as duty counsel in Portage la Prairie, Garden Hill First Nation, which is a fly-in community sort of in the northeast of Manitoba, sort of over where Manitoba curves over Ontario, about halfway up. And he also does drug treatment court here in Winnipeg, and his office also covers mental health court. So, So with that, I will pass it on to you, John. And what I'm going to do, if you give me 1 sec here, I'm just going to bring up your share screen first and make sure that everybody can see this. So share. Wait. Give me 1 sec, everyone's slideshow. Start from first slide. Okay, can someone online tell us, can you guys see the screen right now that says how to do a dispo?
Yes, we can see it.
Perfect. All right. Having said that then, John, I'll let you take over. And
How do I change slides? Just with
yeah,
this?
with the arrow.
Okay. All right. So hi, everyone. So I'm just going to talk kind of generally what to expect with a disposition and how to approach a file. Just give you some practical tips about how to do that. This is a subject that you can cover over many hours. So I'll just try to give you kind of a condensed version of stuff that you'll likely be dealing with when you're articling. You're probably going to deal with a lot of bail court dispos. So you're going to be dealing with things like breaches of probation, theft under, failure to appear, stuff like that. So I'll kind of cover, most of dispositions in general, and then try to keep it kind of specific to that too, the stuff that you'll be dealing with, and just some practical tips. So okay, so the first thing is how to approach a file. So one of the things you want to look for is just make sure you have all the disclosure. Okay, so you should have everything that the Crown has. When you're doing bail court dispos, you may not have complete disclosure. You have to use your discretion on it, right? Like if it's a breach of probation, you should at least have the probation officer's report, right, to know exactly kind of what the substance of the charge is. So but yeah, you'll want to go through it, make sure your disclosure is complete. So, look for things like statements. Does the complainant make a statement? Is there anything outstanding in that regard? Police narratives. Some things that you'll have to specifically request are going to be like the ITO or 911 calls. They will give you those 911 calls, but you have to specifically request them. They're not going to just give it to you in the normal course of things. Same with the ITO too. So when I say ITO, it's an information to obtain. So that's in warrant cases. So in order to get a warrant, as the police have to swear an affidavit and apply in what's called an information to obtain, or an ITO. Again, that's something that you have to request specifically. They're just not going to give it to you as part of the disclosure. If you request it, though, they'll go through a process. They have to look if they have to redact anything, if there's confidential informants and stuff like that. So just keep that in mind. And again, you'll see that in warrant cases. So you typically see it in drug type of cases. Once you have the disclosure, you're going to want to look for any kind of triable issues. So again, you're looking for, not only did your client do it, I mean, obviously that's the first step, is whether or not they're admitting the facts, right? Because if they're not, then we're not in a disposition type of situation, right? Having said that, even if they're admitting the offense, you still got to look at the triable issues. It's not necessarily what happened, it's what the Crown can prove happened, right? So you're going to look at some things like charter issues. So look at what are the issues if it's a drug or a weapons case, or the issues with the search or the detention. So you want to turn your mind to that. If they make a confession, are there 10A, 10B issues? Make sure you turn your mind to that. Identification, can they prove it's your client? Who identifies them? How do they identify them? Is it in a surveillance video? Is it a situation where there's recognition evidence, like someone who knows the accused says, yeah, that's him. How do they know him? That kind of thing. You also want to assess the level of cooperation with the witnesses and the complainants. So, I mean, you typically see that in domestic violence cases. So often you'll have, persons in for allegedly assaulting their spouse. Does the spouse make any kind of statement, right? Or is it clear in the police report that they don't really want to proceed with this? If that's the case, then this probably isn't going to go anywhere. You might want to look at other options in terms of maybe not proceeding with the disposition if it's unlikely the complainant is going to be cooperative. In terms of possession, again, so that's another issue you'll want to look at. Again, you'll see that mainly in drug cases, weapon cases. So two main things for possession is knowledge and control, right? So the person has to know that the things there, the drugs are there, and the person has to be able to exercise some degree of control. Okay? There's obviously different types of possession. There's joint possession, constructive possession, but you still have to have those basic elements of knowledge and control. So, often you'll see, okay, drugs were found in the car. Your client may have been driving the car. Arguably, they have control over those drugs. But do they have knowledge that the drugs are actually in the trunk, right? Maybe it's in someone's bag with some other person's ID and that kind of thing. And so there's a real issue in terms of the knowledge. If you have something with, usually you see this in assault is it a consent fight, right? There are two people just fighting each other, then we're not in an assault situation, right? Or turn your mind to self-defense too, right? Just kind of how did things play out and what your client's position is on that. Also turn your mind to whether or not there's any issues with fitness or NCR. So, fitness, I mean, it's a pretty low bar to reach. Basically, the client just has to know essentially what the essential roles are of everyone so that the judge, prosecutor, defense, it's a pretty low bar to meet. Having said that, if you do have concerns, you'll want to potentially look at getting a fitness assessment and see if you can even take instructions. So you turn your mind to that. Usually it'll be pretty obvious when you're talking to your client if that's an issue. So often isn't, but it does become an issue. Same thing with NCR too. So NCR, you're looking at, usually they kind of go hand in hand, but they are separate. And NCR, you're going to be looking, okay, did the person actually know what they were doing at the time? Could they appreciate the consequences of their actions? So just make sure you turn your mind to that. Those don't come up tons, but they are issues that you just want to flag too. So you have the disclosure, you're interviewing your client. So again, you want to have most of the disclosure. In terms of what you're reviewing with your client, typically you're going to be under the gun in terms of time usually. So you want to use your time appropriately. If you're in bail court, you're doing a disposition. Some of the things that I'll hit on are read the arrest report. I usually just go through that and just read it to my clients. It's usually not very long. You're usually looking at a page, 2 pages for an arrest report. If there's a statement, like a paper statement, I'll read that too in its entirety to my clients, just because that's going to mainly be, if it's a WD scenario, that's going to be essentially what the case is against them, right? There's going to be other things like, police narratives, things like that. I usually don't go through that. I mean, you're going to spend all day going through that with your client if you do it word for word. So I'll usually just summarize it. So I'll read the arrest report and say, there's another officer who observed this as well. And this is what they say kind of in the report. Obviously, you want to get your client's position on what happened, right? So again, as I talked about, if they're admitting it, I mean, that's kind of step one with a disposition. If they're not, then we're not talking a disposition. But even then, turn your mind to those issues if the Crown can prove the case or not. Basically, what you're looking for is if your client's agreeing with the essential elements of the offense. Often you'll find times where they agree the essential elements of the offense, but they'll say, well, that other part didn't happen, or, that aggravating part didn't happen. If that's the case, you'll want to talk to the Crown about, my client's willing to admit this, but not this part. So it's not an all facts basis, and that would be part of your plea negotiation. You're probably not going to be dealing with this as an articling student, but ultimately, if you can't agree on the facts, you might find yourself in a Gardner hearing type of situation where your client agrees to enter the guilty plea, and then you call evidence on, or the Crown calls evidence on the aggravating facts, and your client may testify in that situation as well. Those don't normally happen. Normally, we're able to work out some kind of resolution, particularly if your client's offering a plea. I mean, the Crown's usually willing to negotiate the facts to a certain degree. Some things to touch on with your interview with the client. So obviously you want to look for glad do factors. So talk to your client about that. Any addictions, issues, or any treatments. So has your client struggled with addictions? It should be pretty obvious in terms of the arrest report with them. You'll want to know, have they done any treatment in the past? If they have, what was it? How did that work? If it didn't work, why didn't it work? That kind of thing. You also want to ask them about any kind of community support. So often our clients will have some level of support in the community. So is it turning leave, CLDS? You'll want to follow up with that, get contact information for any people that they may have in the community, and then any diagnosis that they may have too. And your client may or may not know that, but you'll want to just canvass that with them if they're aware of any kind of diagnosis. Did they meet with someone in the past? That they met with a doctor? You kind of want to ask those questions. And they'll may or may not be able to tell you that. But if you do get the community supports and you get the contact information for those people, often that will lead you down the path of getting any kind of prior assessments or prior reports. And that's stuff that you want to look at because often your client's not going to be in a position to tell you exactly and happen. But if you can get that lead, that will be of assistance with both your negotiations with the Crown and also just ultimately when you proceed with the sentencing as well. Other things I usually ask is education. You know, what's your level of education? If you dropped out of high school or school, why was that? Often, you know, we'll have clients who have struggling with addictions issues. That's why they dropped out. You know, your client may have been a young mother at 15, dropped out because they had a child. Those are all factors that you'll want to hit on and will be relevant for the sentencing. Ask about their employment and their financial circumstances. You'll particularly want that for fines. If a fine is on the table, you want to know, okay, how much does your client make each month? What are their obligations? You know, maybe they're doing fairly well financially, which probably won't be the case if you're doing a legal aid disposition. But if, you know, they do have an income, okay, maybe they have like 5 kids though that they have to support too, right? And there's not much money at the end of it. So make sure you canvass that. Also going to be relevant for costs and surcharges too. Make sure you turn your mind to that. I almost always ask those be waived. There's only a few situations where my client's actually working and it's actually appropriate. So make sure you turn your mind to whether or not costs and surcharges are going to be appropriate. The last point there is that's really more for domestic violence cases. So does the complainant and your client, do they have children together? Because that's often the case. Find out what the situation is there. Is there, you know, a formal court order in place in terms of any family law proceedings? What's the custody arrangements? Do they have some kind of informal arrangement? You want to turn your mind to, you know, any new contacts? Do you need a third party exception for child access, that kind of thing? So make sure that you turn your mind to that. You'll see that not only with your bail submissions, just in general, but also for obviously for probation. That's going to be important, right? So you don't want to see a situation where there's just an absolute no contact. They have 3 kids together and your client's on a probation order for 2 years where they have no means to actually see their child absent of mediation. So you want to address that on the front end. Look at the criminal record. So some things on your client's criminal record that I look for would be gaps in the record, right? So is your client been out of trouble for a 10-year period? Okay, if so, why was that? What were they doing around that period of time? Is it a situation where, you know, they very recently got involved? They're, you know, 30 years old, no prior involvement. All of a sudden they've got a number of different charges. Well, why is that, right? Is it an addictions issue or what's going on? You want to see, do they have any related convictions? So, you know, if they have 5 other domestic violence convictions, that's going to be an aggravating factor, right? So you want to look at that. Again, is it with the same complainant too, right? So again, that might be something that that's the Crown will raise in terms of the sentence. And I already covered in terms of no record, like why the sudden involvement. I mean, you often see that. I've had clients who 30, 40 years old, no involvement in the criminal justice system, and then within a 6-month period of time, they've accumulated like 10 different sets of charges, right? So usually that's because there's some kind of drug addiction going on or some kind of mental health issue going on. That'll kind of lead you down that path about that further conversation with them about, okay, what's going on here and, you know, how do we address that and craft your submissions around that. So negotiating with the Crown. So your advocacy really does start outside of the courtroom. Yeah, it starts when you're negotiating with the Crown. That's really when you're starting to advocate for your client. It's a lot easier to get the Crown to agree with you and go in there with a joint recommendation. I mean, that doesn't always happen, but that's your first step, right? If you can get that, then your client's in a better position. So what I'll typically do when I'm negotiating with the Crown is I'll give the Crown a lot of background information about my client. And I think that's helpful because the Crown is just reading how your client's such a bad person on paper, right? They don't see the actual human element to that. So provide your client's background, so the glad-do factors, what's been going on in their life, kind of what's led to the offense and that kind of thing. You also want to consider the weaknesses in the Crown's case. I mean, majority of the time, the Crown is going to recognize what the weaknesses are in their case, but you may want to point that out to them just in terms of assisting with your negotiations. You want to be a little bit careful with that too. I usually only do that if it's something that's plainly obvious in terms of the disclosure the Crown already has. I won't necessarily, if I have something in my back pocket, I won't necessarily bring that up at this stage because, we haven't quite resolved. That may still be something I want to use at trial that maybe I don't want to disclose to the Crown at this point. But if there's issues like, say, a charter issue, right? There's an issue with the detention or the search. That's going to be pretty obvious on the face of it. So you may just want to highlight that for the Crown. Consider whether or not a joint recommendation is appropriate. So I'm sure you all are probably familiar with Anthony Cook's. That's the main case on that. So, think about if it's a true plea bargain. So what's kind of the quid pro quo with that and turn your mind to that. You maybe, as part of the plea negotiation, you want to consider a plea to a lesser charge. So if your client's charged with assault caused bodily harm, well, maybe we could plead it down to assault, right? And we're kind of in a different sentencing range. So that'll be part of your discussions. And then in terms of again, as I said at the outset, a lot of the things that you're going to be dealing with are breaches of probation, failure to appear, that kind of thing. So you'll want to maybe turn your mind to amending the information. So typically what you see is someone will not show up for reporting appointments, right? And then they'll get breached and then they'll get released and then they'll not show up again for the reporting appointments. Then they'll get a separate set of breaches and that kind of continues and they'll probably miss a court date in between then too. So turn your mind to amending the counts. So usually I'll say, okay, well, they have these 3 different sets of probation breaches. We'll amend the dates to include the entire set, but do it as one charge. So it helps your client in terms of the record as well, and also just for sentencing. Same thing with the failure to appears too. You can either do kind of an amended type of situation, or with failure to appears, you're more likely going to they'll plead to, 2 out of the 5, and we can do it on a whole facts basis if they're insisting on that. Saying, yeah, he missed a bunch of court dates, but he's pleaded to these 2, right? Some things to consider, again, this is still at the negotiation phase with the Crown. Is a pre-sentence report appropriate? So you're probably not going to see a lot of this in terms of when you're articling, but later on in your practice, it's something that you'll contend with. Don't just order a pre-sentence report automatically. It's tempting when the Crown's asking for jail just to ask for one because it's kind of a safety net, like, well, maybe I should get that. Really think it through. Some clients don't do well with probation services, don't do well in a pre-sentence report. It can actually hurt your position or hurt your client's position. So think about that. I mean, the majority of the time they are useful and your client will do relatively well because you'll talk to them about how they need to do well. Like, you're not going to tell them what to say, but I usually tell my clients that, look, you're going to be talking to a probation officer. Anything you say to that probation officer is going to be in that report. That report's going to be read by the judge. So don't say anything you wouldn't say in court, right? But you may have a client who is absolutely not remorseful and says, no, that person deserved it and I'd do it again and that kind of thing. Probably not a good idea to get a pre-sentence report. In that case, I would just get extensive background and just waive the pre-sentence report. Try to talk to my client, obviously, about that. But you may always want to forego the pre-sentence report in those situations. So the other thing too is consider how long a probation or a pre-sentence report would take to be prepared. So right now, the timelines for with glad do for in custody are 5 weeks. Out of custody is 12 weeks with a glad do, 10 weeks without. So, is your client in custody and maybe they've accumulated some time in already and they're not really looking at time going forward, is the pre-sentence report ultimately going to maybe keep them in custody for longer? So you may just turn your mind to that. One of the main benefits, I think, from a pre-sentence report is it does give that fulsome background information, but it also allows the information to be before the court without having to raise it in oral argument. So a lot of our clients have a lot of past trauma, a lot of sensitive issues in their life. It's not always the best thing to have to read that out in open court. So if you get the pre-sentence report, it has that will be before the court. The court will consider that. And, when I'm making my submissions, I may say something to the effect of like, my client has had a lot of trauma in their life. Your Honor has a pre-sentence report that's discussed at, pages 5 to 6 or whatever. And just leave it at that. So the judge will understand where you're coming from. They'll have that information, but you don't necessarily need to address it in open court, which can be difficult for your client. Just a practical tip. I know some judges, this will be a pet peeve for them. You don't order a pre-sentence report. You're asking the court to order a pre-sentence report. So don't say, we're ordering a pre-sentence report. Say we're asking the court to order a pre-sentence report when you do order one. And then just in terms of going back to, again, the negotiation with the Crown. So are there any facts that are in dispute? So remember, the Crown has to prove any aggravating factors beyond a reasonable doubt. So turn your mind to that. Again, that would be part of the negotiations is your client's willing to plead guilty, but not if these facts are being read in. So make sure that's clear from the outset, because you don't want to find yourself in a situation where you're in the middle of a disposition and there's this argument about facts that comes up. Don't be afraid to propose the pleas in the sentence recommendation. Sometimes that's a good strategy, depending on who you're dealing with for the Crown's office. I mean, the Crowns are like anyone, they're busy, right? So if you outline a position for them and say, I'm suggesting guilty pleas to this is my sentence, this is what I think is appropriate for a sentence. Sometimes the Crown, if they were, maybe not going to go quite that lenient, but they're like, that's kind of what I was thinking in the range, they might cut your client a bit of a break just because it's easier, right? So that could be an effective strategy too. Sometimes, though, depending on who you're dealing with, sometimes you may want them to make the first offer too and just say, here's my client's background, can you give me a position on it? So it kind of depends on the circumstances, but something to consider. You also want to consider any alternatives to sentencing, right? So are there alternative measures that we can take? So maybe diversion's appropriate, right? So you can do pre-plea diversion. So that's your client's been charged. Just go through the diversion process, make sure they're willing to engage in diversion. Usually I tell them kind of what that entails is you'll have to do some anger management or some, addictions counseling. One thing that we're seeing more often now too is there's usually a peace bond at the end of diversion. So make sure that you canvass that with your client and see how they feel about it. Because if they're absolutely against it, then then they might as well not go through the diversion process, right? Because if that's going to be a condition of it. Having said that, sometimes it's not clear whether or not the Crown's going to ask for a peace bond. A lot of times, that will depend on what the client or the complainant wants at the end of it, right? So I usually just alert that to my clients, like this could be something that they'd be seeking at the end of it. Brings us down to the peace bond too. So maybe just a straight up peace bond is the best way to handle this, right? So maybe it's, your client has done some counseling or counseling is not really appropriate for whatever reason, maybe just a peace bond for protective conditions. You can do a peace bond two ways. You can do it under the criminal code or you can do it under the common law. Common law is a lower threshold, so there just has to be a reasonable apprehension of breach of the peace. So usually that, depending on the circumstances, that may be a way that you get around kind of the requirements in the criminal code where there has to be a reasonable apprehension of fear. So that's something to turn your mind to. That can get a little nuanced. A lot of judges aren't going to give you a lot of grief on the basis for a peace bond, but it's some judges will ask the basis of it too. So make sure you turn your mind to that as well. Other things to consider. So some of the other courts like FASD court, right? So is FASD, does your client have a diagnosis or is it a concern? Even if you don't have a diagnosis, if it's a concern, I think if they're under 25, you can still refer them to that court and they can look for assessments and assist you with that. I think Tanis Tudil is still the person doing that. Very helpful. Can assist you to do a lot of the legwork. Quick, they'll look at the hospital records and things like that to see if there's been any kind of diagnosis. So turn your mind to whether or not that court's appropriate. Any of the therapeutic courts, so mental health court, drug treatment court. Again, those are both out of my office. We do duty counsel for both of those courts. They both follow similar formats. Mental health court, though, you also have the benefit of what's called the pre-plea program. So it's kind of like diversion. It's a shorter version of mental health court, and your client doesn't have to enter a guilty plea. So basically, it's just to connect your client with some resources. Usually it lasts for about 6 months or so. And again, they don't have to enter a plea. They just have to meet the requirements of the program. And more likely than not, you're going to deal with in a post-plea situation. That's the full gamut of mental health court. So that's usually about 18 months is kind of depending on how the client does. And there's a number of things that they'll have to do for that program. If your client is interested in it, the first thing you need to decide is, okay, or determine is there some kind of diagnosis? And you need to kind of get the front on that. And then there's a formal application process that you go through. Drug treatment court, we don't have that pre-plea option. So it's just the regular stream. Again, you're probably looking around the 18-month mark for your client to complete it. Again, there's a formal process or application to do with that. So if it's something that your client's looking at, you can always contact me. I'm duty counsel there. I have the forms and I can walk you kind of through the process. Another thing to consider too is an outright stay of proceedings appropriate? So don't be afraid to ask for that if that's appropriate in the circumstances. So, I've had situations where someone commits a crime, relatively minor, say like a theft done or a simple assault. They go to warrant status and they're out of trouble for 8 years and then they get arrested on it again. Okay, well, like this person's been out of trouble for 8 years. Is anyone even interested in the prosecution, right? Because the Crown has to have their charging criteria, right? So is there a reasonable likelihood of conviction and is it in the public interest to proceed? So maybe it's not either of those in that situation. So don't be afraid to say, look, or this should just be an outright state. Or maybe your client has done some addictions counseling or something like that in the meantime, and Crown position otherwise would have been diverged or something like, well, I appreciate this Crown position, but they've already done this program here. How about we just send it to stay if you confirm that? So there's some things that kind of keep in mind when you're looking at the file. When you're preparing for the hearing, so you want to turn your mind to, are you filing any material? Again, as an articling student dealing with the matters that you're dealing with, you're probably not going to file any material, but you may have things like support letters from different people. So family members, friends, employers, things like that. Generally, you'll want to file those in advance. If you have like 1 or 2 letters, you don't need to necessarily file that in advance. You can just do it in your submissions. If you're filing it, I had one this week where I had 9 different support letters. So I filed that in advance so that the judge had it. So I wasn't doing that at mid submissions. If you're filing a case law, again, you're probably not going to be filing case law when you're doing your articles, but something you may do later on in your career. If you're doing that, keep it on point. So you'll file a case law, maybe it's for the sake of parity, or maybe it's for a certain legal principle. So kind of identify why you'd file it. Generally try to keep it to Manitoba or Supreme Court of Canada. I mean, those are, binding, right? If it's a higher court in Manitoba or Supreme Court of Canada. Persuasive though, if it's from like the Ontario Court of Appeal. So if you're doing a different province, you generally want an appellate court. Having said that, if it's something that's really on point factually, maybe you want to file that too. So kind of depends. Any medical reports or psychological assessments. So look at that. That's stuff that you may have got from your community, from the client's community support. So, if they do have any kind of assessments were done or there's a medical issue and you have documentation for that, you may consider filing that. You always want to discuss that in advance with your client and make sure they're comfortable with that, right? I usually tell them, okay, I'm thinking I've got this report, we'll review it with them. I'm thinking about filing that. How do you feel about that? They're okay with it, but something you definitely want to talk to them in advance with. As I already covered, if you're filing anything that's going to be lengthy, do it in advance. Case law, typically you're going to file in advance. I mean, unless it's a really brief case, but generally don't be filing case law, mid submissions or right before, file it in advance. So, when you're preparing your client for the disposition, you'll want to go through the plea inquiry with the client. So, you're going to say, okay, you're going to be pleading guilty to X offense. I'm going to ask you these questions. Is anyone forcing you to plead guilty? You understand by pleading guilty, you're waiving your right to a trial, and you understand that it's the judge that makes the determination on sentence, right? So I'll just kind of walk them through that so that when we get to that point, especially if your client doesn't have a record or has minimal involvement with the criminal justice system, just so they know kind of what to expect. So you want to discuss any ancillary orders with your client. So, is DNA an issue? Is it mandatory? Is it primary, secondary? So talk to your client about DNA just so they know that that's going to be something that the court will impose. Any weapons prohibitions. So with the weapon prohibition, you also want to turn your mind to, okay, does your client hunt for sustenance? Do they need a section 113 exception? So talk to them about that. Any immigration issues that could arise. So make sure you find out your client's immigration status, because that could be an issue. I think I talked about this later in the presentation, but if immigration is an issue, I usually refer them to an immigration lawyer well in advance of getting to the disposition so that they have that opportunity to consult with an immigration lawyer. I tell my clients, I don't have enough expertise to tell you how to go or navigate the immigration aspect or a piece of this. I can just flag it for you that it's going to potentially be an issue. Highway Traffic Act too. So are there any consequences of the HTA? So, I mean, obviously you get with the, impaireds and things like that, you're going to get it. But some things that people often forget is if it is a mischief under to a vehicle, right? You're looking at an HTA consequence. If you're dealing drugs out of the vehicle, that's going to have HTA consequences. So it's section 226, I think, of the Highway Traffic Act that deals with that. You also want to talk to your client too ahead of time. Is there anything that they want to say to the court too? Because the court will ask them if there's anything they want to say. Again, I tell my clients I'm not going to tell you what to say, but like, are you thinking about saying something? What is it? Because you want to know that in advance, because sometimes that doesn't go well. And just so they're not caught off guard about that too. So during the plea inquiry, so the first thing is there an election? So the Crown will say how they're proceeding. I mean, most everything's a hybrid offense nowadays, or strictly indictable. You're going to be, if you're in PJC, you're going to be waiving the reading of the election, right? So you're electing PJC if you're at this point where you're proceeding with the disposition in provincial court. But that'll just be something that comes up. So when you hear the Crown says summary proceedings, that's you don't have an election, right? It's only if it's indictable. So what I do at the plea inquiry is I generally give a brief description of the facts before I go through the plea inquiry. So I'll say, there's on such and such date, you attended to the winners, you stole 5 jackets, left without paying, you were apprehended by the loss prevention officer. I understand you wish to enter a guilty plea to theft under. Is that correct? And it does a few things. It just makes the record clear that they understand what they're pleading to. It also kind of alerts the judge to, okay, what were the facts surrounding that? And it can also take the wind out of the Crown sails too. If they're all kind of geared up, I'm going to read you all these facts, and they're just like, oh yeah, what he said basically, right? So strategically, it can be to your client's advantage too. And again, you just go through the plea inquiry. So you have to go through, is anyone forcing them or pressuring them to plead guilty? You got to confirm that they understand that they're giving up the right to a trial. Make sure your client understands what a trial is. Generally speaking, your adult clients are going to know what a trial is. This is really more for youth clients. I always go through what a trial is with a youth client. I'll often ask my youth clients, okay, if they say, yeah, I know what a trial is. Like, okay, can you just tell me what you think a trial is? Just to get them in their own words, telling you, because sometimes they may have it completely wrong, right? So you will definitely want to discuss that with them and then address that in the plea inquiry. If it's a joint recommendation, you obviously have to make it clear during the plea inquiry that it's up to the court to decide the sentence. The judge does not have to go along with the joint recommendation. Generally too, I will state what the sentence is during the plea inquiry or what the recommendation is. So if, for instance, a joint recommendation for time served and probation, I'll say, you understand that the Crown Attorney and I have a joint recommendation for time served and probation, but it's still up to the judge to determine your sentence, and the judge can sentence you to something different. Even if we're not joint, I'll say, you understand the Crown's asking for this amount of time. You understand I'm asking for this amount of time. It'll be up to the judge to determine. And that also just kind of alerts the judge too to where you're going with this, right? So before you even make your submissions, the judge is like, okay, I know, the respective position of the parties, and you're the one providing the judge with that information. Is there a minimum sentence? So, turn your mind to that. So is there a minimum fine, minimum jail periods? You want to cover that in the plea inquiry. Any other consequences, cover that in the plea inquiry. So that's where we talk about like the Highway Traffic Act, make sure you address that with them. There could be additional consequences through MPI for your license and immigration. There's going to be immigration consequences. Make sure the client confirms that on the record. Also helps you protect yourself too. So the person doesn't come back and say, after they get convicted, be like, I didn't realize that I was going to get deported or that this was going to be an issue, right? Just as a practical tip too, so we talk a little bit about how when you amend the information, say with like probation breaches, you're always going to go back in time. So you're going to start with the last breach and amend backwards. A lot of judges won't give you any grief on that. Some will though. The reason being is you can't go from the first date to the last date because the last date hasn't happened on the first information, right? So that's why you got to go backwards. Now, as I said, 99% of the time that won't be an issue. There are some judges that will call you out on that. So just remember you go for the last date and time and go work back to the first date. Yeah.
I'm assuming there has to be consent for the amendment, right?
Yeah. That's something you'll work out ahead of time. Yeah. Just some practical tips for the sentencing. So you want to have bullet points. Usually I'll have, I'll go through, I'll have background. I'll just have my client's background. I'll maybe have at the outset sentence recommendation where I'll kind of go walk the judge through my recommendation and why I'm recommending that. Criminal record, is there any issues that I need to address? And then the facts as well. So I'll have an explanation for any of the mitigating factors or why something happened. Maybe your client has a reasonable explanation for how things unfolded. Maybe there was a level of provocation or something that makes it more mitigating. Sometimes you won't have anything for the facts. The facts are what they are. You usually, I'll just say the court has the facts and I won't comment any further than that. But if there is an issue that is mitigating for your client in terms of the facts, you'll want to just address that and highlight for that for the court. Also, if your client's done any kind of rehabilitative effort, so if they've completed AFM or something, they did a residential treatment, usually I'll have a letter from AFM, right, and I'll maybe file that letter. And that's one of those situations where you just file it while you're doing your submissions and say, like, I do have a letter confirming that, if I can file that with the court right now. And again, because it's only like a page or so. Some other things to consider too, has your client been on strict bail conditions? So like maybe your client's been on an absolute curfew for the past 3 months, right? That's going to be relevant, particularly maybe you're pitching a CSO, right? And they'll show that they can do that on their bail. So that's something you want to highlight. No issues, well, in the community on bail. Just another practical tip when you're making your submissions, watch the judge's reactions. I also watch the judge's reactions when the Crown's making their submissions, right? Is the Crown saying something where the judge is writing down a lot and they're like, okay, well, they're really kind of biting on that argument. Writing means they like the argument. Or is the judge sitting there with their arms crossed and, not really listening to the Crown, right? They're probably not buying that argument so much. So pay attention to the body language. If you see the judge writing, slow down. Because that means the judge is really on your point and you want to make sure that the judge has your point on that. So just slow down, make sure the pace is good because you don't want the judge to miss anything that you're saying, and particularly if it's a particularly important point. When the Crown's making their submissions, you want to obviously pay attention to what they're saying. Don't just focus on your argument. Make sure you understand and listen to what they're saying. You're not going to object in the middle of the Crown submissions, right? But if you disagree with something, I just make a note on a piece of paper saying, okay, address that, right? And then you'll just address that in your submissions. If the Crown's ends with a point that I don't agree with, I'll usually just pick up on that point right from the outset. I'll say, just from the outset, I want to address that last point that was raised by my learned friend and kind of do it that way. You want to consider the principle of totality if there's multiple offenses. That's if you're dealing with consecutive sentences, so turn your mind to that. And then keep in mind the principles of sentencing in the criminal code. I'm sure everyone's familiar with the sections there. So let's go through that. Just some other practical tips is you want to anticipate any questions that the judge may have. So you kind of get a feel for that as you go. So for instance, we talked about your client's 4 years old, no involvement in the criminal justice system up till recently. What kind of begs the question why, right? So you be prepared for the judge to say, well, what's going on here, right? And that's where you'll get, okay, well, they recently started a drug addiction or there was some family difficulty or whatever it is. We already talked about being mindful of costs and surcharges. So it's, I think, $102 if it's just, a regular probation or custody. If it's a fine, you're looking at 30% of the fine. So obviously that can be quite a bit, right? If you're recommending a fine that's several $1,000s, make sure you talk to your client about that's a potential that could happen and argue that, the surcharge should be waived under the circumstances given your client's financial circumstances. You also want to canvass with your client any plans upon release from custody. So you'll typically receive those in time in custody dispositions. So your client's been in for the past couple of months. Often our clients are homeless, they're transient, they have issues with housing. I typically try to address that as early as I can. So let's say I see a client and, I'm nowhere leaning towards disposition. I know it's probably going to be in the next few months. I'll tell the client, look, you're probably looking at a time served in the next 2 months. Start looking at options now, and start calling people. Are there community supports we can follow up with and get the ball rolling on that? Because it's never a good thing where you're going in and you're basically saying, well, it's time served. I have no idea where he's going to go and what's going to happen after this, right? Particularly if you're asking for probation too, right? So because that's going to just cause all kinds of problems just practically for your client in terms of reporting and how that's going to work. When you are done, you're doing your LAMIS, you'll close the file at LAMIS. I always record the pleas. So what my client entered a plea to, so guilty plea to theft under stated proceedings on the balance, and then record the actual sentence that was done too. So you want to do that. If you're recommending a specific sentence, look at whether or not there's a certain legal test for that sentence recommendation. So two ones I just flagged here for a conditional sentence order, right? So you have to meet certain criteria. It has to be under 2 years. They can't endanger the safety of the public and has to be in accordance with the fundamental principles of sentencing, right? So you have to hit on those tests. Same with a conditional discharge. Is it in your client's best interest? It almost always is. Having said that, if you just gloss over that, some judges will call you out on that and say, well, can you explain to me a little bit further? So don't just ignore that part of the test. And then is it whether or not it's contrary to the public interest, right? So you look at things like, are there a lot of glad do factors? Are there particular unique circumstances around this? Has your client already got a significant punishment? Maybe you're recommending a conditional discharge, but they spent the weekend in jail before they ended up getting bail, right? So that's an additional consequence that they would have had, even though you're not asking for the court to note any time on the record. Just talk a little bit about joint recommendations. So I already talked about Anthony Cook. Be prepared to defend the joint recommendation. Don't just walk in there and assume, oh, I've got a joint recommendation, judge is going to accept this and I'll just move on, right? I think that's a pretty big pet peeve for a lot of judges, just getting treated like a rubber stamp and saying, you have to accept this. So be prepared to defend the joint recommendation. So you want to turn your mind to, okay, is there a quid pro quo? Like, what is this a true plea bargaining situation, right? So that's when you kind of go back to, okay, what were the issues in the case, right? Was there a charter issue? Was there an ID issue or what is it, right? And then if the judge starts questioning the joint recommendation, you say, well, Your Honor, there was this potential avenue that he could have explored or she could have explored at trial. There was a potential charter issue that could have been pursued, and that helps sell the joint recommendation more. It needs to be joined on all aspects of the sentence. So you can't be like, yeah, we agree on, custody here, but not on probation, right? If it's for that specific charge, you have to be joined on all aspects. Otherwise, it isn't a true joint recommendation. When you do have a joint recommendation, you really don't need to go into the nitty gritty of your client's background, particularly if they have that trauma that they've been through. Don't start going through how your client was abused when they were a child and all this other stuff, right? Be prepared to address that if you need to. And if that becomes something that you need to address, sure, have it in your back pocket, but don't raise it unless you need to. Sometimes how I'll typically address that is to say, my client, there's a number of glad do factors. There was some significant difficulties or abuse in the home growing up. I won't get into it any further unless Your Honor has any questions, and just kind of move on for that. So that's, you're still respecting your client's trauma and how that could affect them. But still getting the point across about there was a lot that went into the joint recommendation there. Sometimes you'll say, there's a lot of glad do factors and a lot of trauma that's my client's experienced. I've discussed that with my learned friend, and that's gone into the joint recommendation that we have before the court. I'll just briefly kind of go through the different types of sentences. So we already talked a little bit about a conditional sentence order. So CSOs they're available for a lot more offenses now since the amendments. It used to be that they weren't always available, but they're available for a lot now, which is nice. But again, there's certain criteria that they have to have, right? You can't have a minimum sentence. So you can't have a mandatory minimum 1 year and be recommended a CSO. They're still not available for some offenses. I think it's mainly criminal organization type and terrorism type offenses that they're not available for at this point. The length of the sentence, so it has to be less than 2 years. So, if a penitentiary sentence is appropriate, we're not even talking a CSO, right? So that's the first hurdle you got to get over. Is it consistent with the fundamental principles of justice? So, does a CSO meet denunciation and deterrence? And, the Crown usually tries to argue it doesn't, and case law says that it does. So, It goes back to the Prue decision. That's something you'll have to turn your mind to. Just practically for the conditional sentence order, some things that you'll want to look at is pretty standard for people to have 4 hours a week for personal errands on a CSO. That's something you want to discuss with your client in advance. You can do it two different ways. Is you can either have like a set period of time, like maybe your client wants to do Saturdays from noon to 4, right? And that's just a set time. They like having that set time. So you build it and build that in. The other way you can do it though, too, is you could say 4 hours per week as approved in advance by your conditional sentence supervisor. And that essentially gives more flexibility so they don't have that set amount. But it depends on your client and kind of what their lifestyle is and how they want that to go. Having said all that, the point is that you have that 4 hours built in. That's pretty standard. The Crown's not going to give you any grief on that. But discuss with your client in advance kind of how they would like that to be apportioned. I always also include a catch-all with the CSO is except as approved in advance in writing by your CSO supervisor. So that covers things like any kind of doctor's appointments that come up, a funeral that comes up, stuff that we can't necessarily predict at the time of sentencing. But if it's not built into the order, then the CSO supervisor can't do anything about that, right? So you want to make sure you have that residual clause. If you are recommending a CSO, even if it's not joint, if it is joined or it's not joined, have the conditions typed up in advance. So, if the Crown's not joining you, they're obviously not going to have the conditions typed up. So you'll want to have those typed up in advance so that you can provide the court with a copy of it too. So just a practical tip, the judge probably is going to be very happy if you're recommending all these conditions and you haven't really worked them out in advance. So, important for your client to know with the CSO too, that it's a jail sentence, right? So, if they breach, the presumption is they're going to spend the remainder in custody, right? So make sure that they understand that. Make sure you canvass any potential issues with compliance. So what is their living situation, right? Are they living in an apartment? Okay, do you have to get buzzed into the apartment? Are they able to hear that? Do they have a landline? Or, are they in a situation where there's multiple roommates and that might cause an issue? So you just want to canvass that. And in some situations, you can craft conditions to address those issues. Is your client have a stable address too, right? That's one of the things you want to look at as well, because you certainly want to make sure that you address it at the front end. Just in terms of like conditional discharge and absolute discharge. So again, we already touched on how it's the test for that. So again, don't just assume that it's in your client's best interests in terms of things to touch on for whether or not it's contrary to the public interest. So, you'll address if there's any record, any mitigating circumstances, any circumstances around the offense, why it's kind of a one-off type of situation, highlight that there's been no re-involvement since. So those are just some things you want to hit on. I should say too, I think Catherine can distribute this PowerPoint, right? Okay, so yeah, we can just send that out too, just so everyone's aware. Probably should have said that from the outset. Other sentences too, so intermittent sentences. So again, only available for recommended max 90 days, right? If it's above that, you're not going to get an intermittent sentence. Typically, you're going to recommend that if continuous custody would cause some issues. So typically, you'll see that when it would cause issues for your client's employment or for their housing. I've had situations where clients are in band housing, and if the house is vacant for more than 2 weeks, the band might rescind their housing. So that would be an issue. Childcare, right? Is your client, maybe they can arrange for childcare on the weekends or something like that, but they can't go into custody and have arrangements for their kids. So their kids would go into CFS care, right? That's going to be an issue to address. It's a good idea to get documentation for that. So if you're arguing for intermittent because your client is working, it's a good idea to get a letter from the employer just confirming the employment and what the hours of work are, and then you can file that with the court. Typically, the way it would work is you report on Friday evening, you get released Sunday afternoon. It's good in the sense that it actually counts for 3 days, even though you're not serving full 3 days, right? You're really only doing half day, and then a half day, but it would count for 3 days. The flip side of that is you don't get earned remission. So you're serving the full sentence on intermittent, which can take a long time, right? If you're breaking it up, like a 60-day sentence, even over 3 days every weekend, that's going to take a long time to actually to complete. So sometimes people don't want it because of that. They rather say, I'd rather go in for the 60 days. I'll do 45 or whatever it is and be on with it. So In terms of probation, so the max is 3 years for probation. It's only available if you get a custodial sentence that's 2 years or less. To remind you, there should be a nexus between the conditions and the offending behavior. Probation is rehabilitative in nature; it's not punitive in nature. So there has to be, an actual reason for it, for what's being recommended in terms of the conditions. The Crown rarely tries to argue an abstain condition now, but be mindful of that if they are. Is your client struggling with addiction, then probably not a great idea to put an abstain condition on there, right? That's just going to set them up for failure. Consider whether or not supervised probation is appropriate, right? I mean, often that's what the Crown's asking for, but don't just agree to it. Think about whether or not it is actually appropriate in the circumstances. What issues is it actually going to address, right? Like what counseling would benefit your client, or is it a situation where your client's already done a lot of counseling? Is it a situation where your client's already been on probation 10 times and they don't need more probation? They're aware of the resources that are out there. I've had clients who been on probation probably for over 10 years, right? And the argument is they've had probation. They know what it is. They aren't going to comply with the conditions. The flip side is they're probably going to look at a longer custodial sentence, but don't put them on probation. And one of the arguments I think that really gets some traction actually with the court too is just, it's a waste of resources, right? Probation services is really limited in terms of the resources. If we're just putting this person on this probation order, it's supposed to be rehabilitative in nature, and they're just not going to comply with it. It's a waste of everyone's time. So why would we do that, right? Flip side of that too, though, is you may want to see, okay, maybe unsupervised probation is appropriate, right? So that's when you get into protective conditions or not to attend to winners, which is, they're always winners that everyone steals from. So, it might be conditions not to attend certain places, and that can address any kind of protection issues. Again, we already talked about too, no contacts is a domestic situation. Is there an exception for child access, things of that nature? Just provincial versus federal sentences, just briefly. So, provincial is anything 2 years less a day going forward. So going forward is the key with that. So if it's a 3-year sentence, but they've already have a year of time in custody, they're going to remain provincial if it's less than 2 years, 2 years less a day going forward. So your client will go to, Headingley, Milner, Brandon. The big one is for female clients. So they'll go to women's if it's provincial. If it's federal, I think they're still sending them to Edmonton. So that's obviously going to have huge impacts on your client. So make sure you kind of turn your mind to that. Federal would be anything, 2 years or more going forward. So that would be Stoney or out of province. So, for the men, you have the option to remain in province. Having said that, there could be an involuntary transfer. So if your client goes into the penitentiary, they may go out of province, whether they like it or not. And so generally speaking, the institution will try to keep them in the province, but it'll be a whole host of factors including what their case plan is and things like that. So just some things to keep in mind. You also want to consider whether a client wants to go to the penitentiary. Sometimes they do. It's not actually unusual for you to be like around a 20-month recommendation, and the client goes, I want to go to the pen, because there's certain benefits and programs that they can get. So Crown may be asked for 20 months and you do a joint recommendation for 2 years, right? You'll likely want to get written instructions for that, just to make it clear. Often people want to do that too for parole purposes. I always caution my clients that, you're eligible for parole after a third, but that just means you're eligible, right? It's not an automatic thing. You have to go through a hearing. It's not like you hit 1/3 and then automatically you get parole. You may not even get the hearing by 1/3, right? It depends where you're at with your case plan, depends what your plan is in the community. So don't just go into it thinking it's an automatic thing. Generally speaking, for provincial or federal, your client's going to serve 2/3 of their sentence. So in the provincial system, those just get released. If there's probation, they'll kick in. In the federal system, they'll get what's called stat release. So there'll still be conditions that they're under until their warrant expiry or their WED date. And then the WED date is just, it's done. They've served the full amount of their sentence. Just some ancillary orders, some very small print there. So immigration, I'll just touch on some of the highlights. So again, confirm your client's immigration status before you proceed with sentencing. So if it is an issue, then that's something you want to address well before, because If you see this being an issue and they consult with an lawyer, there's some things that they can do with their immigration lawyer to help mitigate the impacts of immigration consequences as well prior to sentencing, and they want to get moving on that right away. Section 36 of the Immigration Refugee Protection Act, or IRPA, is what you want to turn your mind to. So that'll have kind of the issues with inadmissibility. A foreign national convicted of an offense punishable by indictment is inadmissible. A permanent resident convicted of an offense punishable by a max 10 years or more is inadmissible. So that's a tricky one because it's 10 years or more. And a lot of the offenses are 10 years or less, but because it's 10 years, it captures a lot of offenses. So even impaired driving now is captured. So it covers a lot. So you want to check the code to see what the maximum sentence is. But even if it's 10 years or less, you'll still be captured by that because of the 10 years. The length of the sentence matters too for a permanent resident. So if his custody is more than 6 months, they could be deemed inadmissible, even though other criteria isn't met. If the sentence itself is over 6 months, that's going to trigger immigration consequences. Oddly enough, a CSO does not count as custody for the purposes of immigration. So if your client gets a 2-year CSO, there's not an issue with immigration versus if they got 6 months of custody. So that's another thing to turn your mind to as well. Discharges, so conditional discharge up, so discharge not considered a conviction under IRPA. So, maybe your client's on the cusp of a conditional discharge that might sway the court to do a conditional discharge if there's immigration consequences. We already, it can be a relevant factor, but it can't be used to artificially reduce the sentence, right? So there's FAM or Supreme Court of Canada. I think there's the Ali decision from Manitoba Court of Appeal too. So it's a factor for the court to consider, but you can't go in there, my client's pleading guilty to sexual interference and give them, like a 5-month sentence, right? Because of the immigration. That's not going to work out, right? But it is still a relevant consideration for the court to consider. We talked a little bit about Highway Traffic Act offenses. Again, Section 264 of the HTA. So look at that.
Also the MPI consequences. So yeah,
yeah, and that's covered under 264 too. There's actually a table that is under that section. So that'll cover like it puts it in either category A or category B offenses. And there's a table saying like if you have so many category A or so many category B and A or just B's in a 10-year period, it'll tell you what the suspension is. So make sure you look at that.
I probably want to know as well, like if you plead to an impaired, you're getting, I think it's 10 points right now.
Yeah, the demerits with that.
I want to know about that
Yeah.
as well.
Refusal to will net you 2-year license suspension too, regardless of what happens in court. It's 2-year license suspension. Although I think even like a simple impaired, I think you're looking at potentially a 5-year suspension for your license. So
and MPI is completely separate from the court, and sometimes they will give a lifetime suspension. Like you just forewarn the client about that.
So the point being, when you do the plea inquiry to make sure the client knows there's additional consequence for the PI. But check out that table. I mean, if you have one of these cases, just look at that section and that'll tell you exactly what the suspension will be and what they can expect. And you want to address that with your client ahead of time. We already talked about some weapon prohibition. So does your client need Section 113 exception? SOIRA 161 orders. So those are be applicable. DNA. So again, if it's a primary offense, it's going to be mandatory. If it's secondary, then not necessarily going to happen. So want to work that out in advance. Again, this is all things that you want to address in the inquiry. One of the things I put on here, just because this is probably what you're going to be dealing with a lot when you're in bail court, is breaches. So it's not just a mathematical equation. So often it's kind of a pet peeve of mine is often you'll see the Crown go, oh, I got 15 days on his last one, so it's 30 days. That's my position. It's not that simple. It's more nuanced than that. You want to look at things like, what was the context of the breach? Is it, okay, they have 5 other breaches, but they were all abstained breaches, or maybe they were contact breaches and this one's an abstained breach. Well, that's more mitigating than if they're harassing the same person. They have an addictions issue and they just happen to be drinking or doing drugs or whatever it is. If it's like a failure to appear or a reporting breach, look at why. Often our clients are transient. Often they don't have a phone. That causes issues, right? So you want to look at that, and that can be very mitigating under the circumstances. Again, look for gaps in the record too, right? Okay, so maybe they did get 15 days in the last one, but that was 10 years ago, right? That's not really that relevant in terms of when we look at a sentencing because of the date nature of the charge. Francois is a good decision in 2013 from our provincial courts. Judge Slough kind of says basically that you have to look at the context of the breach. So it's a good decision to look up. Look at if your client has the requisite mens rea, right? So look at the Zora decision. So your client has to either intend or be reckless about breaching. So, there could be a defense with that as well. We already talked about considering amending the dates as well. Often what I'll see too with probation breaches in particular is if it's just one or maybe two breaches and your client doesn't have much of a record, check with the Crown, say like, look, they still got another 9 months or whatever it is on probation. Why don't we give them next 3 months, just see how they do on probation? And if they do well, just end up staying the charges. Because ultimately, the issue has been resolved and they're now engaging in probation services. Do they really need a plea on it, right? And I think this is the last one I have, is just to briefly cover youth matters. I think there's probably going to be a lunch and learn on youth matters later on in the year anyway, so I won't spend too much time on it. Just to highlight a few things for you, that you have a lot more tools at your disposal for youth sentencing. So you can request a forensic report in addition to the PSR. You can request things like a bail conference or a sentencing conference. So those are all things that you have with the youth justice system that you don't have for an adult. So turn your mind to whether or not that would be beneficial. Just in terms of sentencing conferences, and this also goes for bail conferences as well. They can be judicially or non-judicially led. So that's one of the things, if you're asking for one, that's the first thing you're going to think of. Does a judge need to attend? And some reasons you may want a judge to attend is maybe you'll roll into a sentencing right then and there. Be a good idea to get the judge there. Or, maybe for scheduling purposes, if you want to get this rolling, maybe it might be faster if we didn't have a judge involved, so you can get it that way. You want to look at whether or not the parties are invited or ordered to attend. So invited just means that an invitation goes out. Ordered is it's a court order, you need to show up. So people who you will invite might be doctors or, some family members, stuff like that. People who you're going to have ordered to attend are things like the caregivers, CFS workers, that kind of thing, so that they have to show up. Again, that's something that you would ask the court to order. When you do that, make sure you have a list of people that you want to have ordered. So like I'll give the list to the clerk, who will then give it to the judge. So usually have the name, kind of the relationship, and then the contact information, and whether or not they're invited or you're asking them to be ordered to attend. Just going back to on reports and that too, one thing to keep in mind is, so these are only available for when your client is a youth, right? So often, you may be like, oh, I don't necessarily need a report for whatever reason, but your client is maybe 17 years old or 16 years old, get the report, because it's going to be much, much harder to get it down the line. And then if you have that, you have that now. If they become re-involved in the adult system, you have that additional report that you wouldn't necessarily be able to get. Keep in mind with youth matters, so there's no mandatory minimum sentences. Keep in mind whether custody is even available. It's not even available. Custody's not on the table, or the door to custody isn't open, as they say. So I think Section 39 of the YCA deals with that. Parts of the YCA that deal with sentencing general, there's Section 3, 4, 38, 39, 42. So those are kind of the main sections you want to look at. And then the other one too is just whether or not it should be open versus closed custody. So open custody, they can leave the institution for some programs that kind of have a lot more freedom. They're usually escorted and that kind of thing, but there's a lot more kind of freedom in terms of movement and rehabilitative opportunities. Closed custody is they're staying. Usually, I think it's Agassiz is still operating. It's been a while since I've done youth matters, but closed custody usually that goes, it'll be in the institution. It's not that off-site training where rehabilitative kind of programming. So I think that's it. Anyone have any questions? Yeah.
It's a lifetime suspension. Like, would an example of that be like someone's had like 3 impaireds, hit someone, altering injuries, something of the like there?
Yeah, I think they actually are just recently changing the legislation on that too, actually, in terms of like drive impairment caused by death. You'd have to check the table, but yeah, it can be up there. It depends on the seriousness of the offense, whether this is a category A or B. It depends on the number of offenses. Those are the two things that'll kind of put you in that. Yep.
Is there anything we need to note or like any technical differences if you're doing the inquiry that's gonna go to post plea diversion?
Not really. And that's like if you're doing a post plea that's going to go, if it's going to go to post plea diversion, I would typically have the Crown maybe read the entire facts on the record. So it's very, very clear. You know, if it doesn't work out, these are the facts, and do it that way. You can do it in that situation. I'll typically you'll work it out with the Crown in advance, but I would typically tell the Crown, look, I want you to read the facts on the record, and then I'll do the plea inquiry. And so they'll read the facts, and you go to your client. You heard the facts. I understand you're agreeing with that. That's the basis for guilty plea. Do I have that right? Well, anyone else? Yep.
So. When you're dealing with a client, do you explain to them this detail for the parts that you're going through so they know? Is this just, I don't know, if you're dealing with 300 matters at once, you kind of have to speed things up, because some people, if they would know the why behind it, they would be a lot more like they could have a more fulsome thought process on what some of these things entail.
Are you talking about just in terms of like doing the plea inquiry or jury?
Well, generally anything you're really discussing with your client is the whole, just, I don't know, just how much time do you spend with them going through all of these things? Because you could go quite in depth, and then they can actually have a really fulsome decision made, or is it just something that you just sort of have to flag as you're going through if you want to talk about it?
Yeah, I mean, it kind of depends on the circumstances, right? At the bare minimum, your client should be aware of what they're pleading to and the consequences of pleading to them, right? And what their options are.
Okay.
Yeah, at the bare minimum, you want to address that. It depends on the circumstances too. I mean, sometimes things are pretty straightforward, right? It's like, why did you show up for probation? Oh, I slept in. Okay, well, there's not much else to kind of go through with that, right? So, but if it's more of there could be more complicated things. The bare minimum, that's what you want to hit on, is that they fully understand what they're getting themselves into. Yeah.
I was just wondering, when it comes to types of sentences, what is a suspended sentence?
So the suspended sentence means in theory, they can bring you back before the court to resentence you. I have never seen that happen in Manitoba. They were trying it back in, I think, 2015. There was this that's when kind of the whole concept of exceptional circumstances kind of became to the forefront of the case law in Manitoba. Peter's decision was the main one. I think they actually did try to resentence him. That was a case where someone was convicted of possession for the purpose of trafficking and got, I think, 3 years probation in the terms of suspended sentence. And so I think he had breached, and they tried to bring him back, actually have him resentenced. So in theory, that's what it means. A suspended sentence means that they're suspending the sentence due to the probation conditions, and you're done. But in theory, if you're not doing it, they can bring you back in front of the court, although that never happens.
Considering that typically a conditional discharge would be more favorable than
Yeah, I mean, at the end of the day, a conditional discharge and suspended sentence are effectively the same thing. They're the same form. It's the result that's different, right? So the end result is your client doesn't get a record with a conditional discharge, and they would get a record with a suspended sentence.
Yeah.
You got there?
Yeah.
Oh, there it is.
Just make this bigger. There we go. I'm just checking the chat here to see if anybody online is, apparently there is. Oh, it says there's chats, but I don't see any. There they go. Thank you so much for your hard work hosting this today. I would love to have a copy of this PowerPoint. Yes, I'm about to email it to everyone. I wanted to ask a question. Mic is not working. Dakota or Cody, if you want to just put a question in the chat, I can read it out. If you're not able to unmute and just speak.
Well, Marion has a question. by the sounds of it.
Is there a consideration to locate, keep federal sentence clients? Hold on a second. Scroll, I can't see that far. Okay, is there a consideration to locate, keep federal sentenced clients near clients' families, example Manitoba?
There is, yeah. It's so when you're dealing with correction, it's under the Corrections Act, right? Or the Correction and Conditional Release Act is I think what the federal one is. So there's certain criteria that they have to meet in order to have what's called an involuntary transfer, and location to family is a consideration. And the inmate can contest it as well, and they have to have a hearing. You're really at that point dealing more with kind of administrative law. And there's kind of different steps that they can go in terms of appealing that decision. Ultimately, you may wind up in a situation where you're doing a judicial review of it or a habeas corpus application. But yeah, there is a procedure that they have to follow.
So Cody, I'm not sure if your mic's not working, you can feel free to type a question in and we'll read it out.
Fine, she put it in.
One new message.
Oh, is there another one in there? Okay. There's the firearms prohibition that is different for First Nations than the regular people. Talk about that. You have to apply the firearms officer at the RCMP for subsistence, but for the First Nations, you let the RCMP know that you are in a hunting party. Going hunting is a little different. Yes, thank you. So I guess you touched a little bit on the accept.
Sorry, I'm trying to read the question. I can't see.
Yeah, that's what. Sorry, thank you. Okay, there is the firearms prohibition that is different for First Nations than regular people. Talk about that. You have to apply to the firearms officer at the RCMP for sustenance. But for the First Nations, you let the RCMP know that you're in a hunting party, going hunting. It's a little different.
I think she's asking, like, with the firearm prohibition, what the exceptions are for Indigenous peoples in Manitoba.
Yeah, and I mean, in terms of how it's actually applied, that's going to be different in terms of than what you're dealing with the sentencing. At the sentencing, you want to identify whether or not a section 113 is appropriate. If your client wants that, and then you'll want to address that in the sentencing. So
I presume a firearms prohibition is about possessing a firearm, but in a hunting party, it's like probably you're applying for the fact that you're going to go with a group to hunt and there's guns around, but it's not your weapon.
no, it's just that you can possess it for that purpose.
Okay, unless anyone else pipes up in the next 30 seconds, I think that concludes this lunch and learn session. So I will circulate the PowerPoint that John just went through to all the students. I'll send it to Allison and have her circulate it to the U of M students. So yeah, if no one else has anything, I want to thank John for coming out and doing this presentation. It's always helpful. We try to have this one a little earlier in the lunch and learn sessions just because it's brand new for everyone and it gives you a little bit of information for the work you're about to be doing. So, all right, thanks everyone. Have a great day.
Good. Yeah.
And
Here, I'm gonna give you this book for Greg.
Okay.
Sure, if can check this one. Cool.
Ciao, folks. It's a pleasure. See you with the next one.
You got it?
Yeah, thank you.
Yeah, no worries.
I just wanted that information in case I have to cite it.
Yeah, that's.
Thank you.